Mr. Frederick.
Thank you, Mr. Chief Justice, and may it please the Court. The 1984 Sentencing Reform Act confirmed that district courts have broad discretion to consider relevant information in imposing and modifying criminal sentences. Section 994T limits only one category of information in compassionate release cases, rehabilitation alone. Section 3661 otherwise imposes, quote, no limitation on the information a court may receive and consider during sentencing. The Third Circuit, however, imposed a judicial limitation on compassionate release. It precluded district courts from considering a change in law that prospectively lowers sentences for offenses like Mr. Rutherford's as one fact in the total mix of information for sentence modifications. That categorical limitation should be reversed. The government concedes that age and illness are ordinary circumstances for inmates. Yet when combined with other factors, age and illness may be extraordinary and compelling in appropriate situations. Whether a change of law is ordinary, therefore, should not matter. Congress did not expressly limit that as a factor in considering modification of extremely long sentences. The Court should reject the government's contention that the 2018 First Step Act impliedly repealed the many provisions of the 1984 Act conferring broad discretion on district courts. I welcome the Court's questions.
Mr. Frederick, it was Congress's choice not to make this retroactive. And it would seem rather odd that you would want to use that decision as a basis or a compelling reason to reduce a sentence that results from the prospective nature of the law.
What Congress did in Section 403B of the First Step Act, Justice Thomas, was to apply it to pending cases. But Congress did not speak to the question of how that rule might apply in the 3582 situation. So Congress was silent with respect to that. It was, as I acknowledge, with respect to pending cases, a narrowed rule about limited retroactivity. But that just means that Congress was leaving to the individual decision-making process in these compassionate release cases up to the discretion of the judge looking at the totality of the circumstances, whether or not the length and duration of a sentence and a disparity might be a relevant circumstance for that particular inmate. I want to point out that the government's principle here is an atextual one, as that came up in the previous argument. Its idea about personal circumstances is nowhere found in the statute, and the idea of extraordinary and compelling depends on the changed circumstances that arise after the person has been sentenced. Justice Kavanaugh, in the earlier case, you inquired about the Sentencing Commission, and I want our position to be very clear about this. The Commission has spoken to the situation that is in Mr. Rutherford and Mr. Carter's cases. If the Commission reversed its course and took those changes of law that are prospective for unusually long sentences, we would have to respect that decision because Congress said that for a compassionate release motion, it had to be done consistent with the Commission's policy statements. So under your hypothetical, as you posed it in the previous case, we win our case. We could lose if the Commission were to change its position.